As families have begun to emerge from this almost self-imposed hibernation, we've been hearing the stories of all of the strain that they've been under. Illness, death, dealing with children with special needs, unemployment, dealing with young children. If you were to add acrimony and animosity to that, it's easy to envision all of the pressure and tension that these families have had to undergo during this time. For some, they've managed, even though they were teetering on divorce or separation, to stay together. And whether that's because they have a new perspective or they're financially constrained, time will tell. But for others, divorce and separation are inevitable. So how do they go about it now? Well, prior to the pandemic, after a short period of time and the papers were filed with the court, they were able to get a preliminary conference. At that time, they would meet with a judge. They would see the judge's perspective, demeanor. The judge would set a schedule on how the case was going to proceed. And the judge would actually tell them what the judge was expecting and probably resolve some of the minor issues. It was a really good opportunity for the litigants to meet the judge and see how the case was going to proceed. But in today's new reality, that is no longer the case. Although that conference is still taking place, it is a Skype conference now with just the attorneys. No litigants are involved. And so they missed this opportunity to speak to the judge. And they're getting secondhand what took place at that conference. Some attorneys will be accurate. Others may spin exactly what took place. And so the litigants are slightly unaware as to what really happened. The other constant in the matrimonial world is that if the case wasn't settled within a period of time, you'd get a trial date. Well, you still can get a trial date, but it won't be the same. It may be a virtual trial date where you're sitting in one room and the judge is sitting in another room, or where some of the litigants are in the courtroom. Harder to see the person's disposition, more difficult to review the exhibits. And I think there'll be even more delays when litigants and attorneys for the children have a preference and not wanting to be in the courtroom, and that will adjourn the trial or reschedule the trial to another date in the future. So what's the bottom line? The bottom line is, if you're going to get divorced now, try to resolve those minor issues. Don't worry about the pots and pans and the 25-year-old couch or the timeshare that neither of you are going to be able to get to in the next 10 years. Focus on what's important: custody, child support, finances. The most important fact that people have to know is that income that formerly supplied one household, after separation now has to supply two households. And the family will never live the way they lived before. They need to understand that. And so get rid of some of these minor issues, because if the court knows that you've resolved these minor issues, it will be more apt to schedule a hearing, whether virtual or in person, sooner than later, because the court will know that it has finalized, isolated issues that are important to the family.